Case number 115932, State of Kansas v. Great Plains of Kiowa County, Inc.
Good morning. Good morning. This case is a case in which the Court of Appeals looked at an issue dealing with the Kansas Open Records Act. Great Plains Kiowa County is a lessee that operates the Kiowa County Memorial Hospital. They have a lease agreement with the Hospital Board of Kiowa County, and their function is as a private nonprofit corporation to operate that hospital. The Kiowa County attorney requested some financial information from the Kiowa County Hospital Board, and then turned around and asked for specific information from Kiowa County Great Plains Hospital. And Great Plains Kiowa County, Inc. responded they were a private corporation and not subject to the Kansas Open Meetings Act. A lawsuit was filed. The district court found that Great Plains Kiowa County was a public agency, fined and ordered the records. We appealed. The Court of Appeals affirmed the trial court, and both sides applied for cert here, and you granted cert to both sides. So here we are. Let me reserve 5 minutes, if I could, for rebuttal.
5 minutes is granted.
We think the Court of Appeals made three basic errors. And the first is that it uncoupled the notion of public agency and public record. And it's unusual, but both sides agree that that was an error. The state and Great Plains Kiowa County suggest that the question of open records and whether records are subject to COMA involves two issues: public agency and public records. Can't have one without the other. So it is actually both that need to be considered in any consideration of whether the Kansas Open Records Act applies. And the Court of Appeals didn't address the issue of whether Great Plains Kiowa County, Inc. was a public agency.
Well, wouldn't you agree that if you fall under the purview of a public agency and an exemption doesn't apply, then the Open Records Act would apply?
Well, if we're a public agency,
right,
and if we have public records and we aren't excluded from coverage.
That's what I said. If you're not excluded, then
I'd agree with that.
Okay.
The second issue is that really, as the Court of Appeals gave their opinion, they focused on the obligations of the hospital board and not Great Plains Kiowa County. And the third issue is exactly what we were just talking about, and that is because they didn't consider whether or not we were a public agency. We didn't get to that question, whether under the statute we are excluded from coverage, because we provide a service. And that's the essence of the three arguments. By the way, we have complete good guidance on this issue from your previous ruling on the Open Meetings Act in Memorial Hospital versus Knudsen. So let me kind of summarize, if I could, what the Court of Appeals ruling said. It basically said the Kiowa County attorneys asked for these records, and we think the hospital board, now understand the hospital board is created by statute. They have the political governmental authority, and they are given by statute the ability to contract for the operation of the hospital. And that's what they did. They contracted with Great Plains Kiowa County, and there's a lease that you have in the record on appeal that spells out what the obligations of Great Plains Kiowa County, Inc. are. But because the hospital board, as a governmental agency, fell within COMA, and because, or CORA, and because they had, the Court of Appeals suspected could have the records, although they didn't, that because it probably amounted to Kiowa County, Great Plains Hospital's responsibility to maintain records, then we should give the county attorney the records because the hospital board, although they didn't have them, they were in the possession of the Great Plains Kiowa County, Inc. The Court of Appeals simply ignored the language of the statute and ignored the language of the lease. The lease gives us the ability to operate the hospital. There is no governmental function about the operation of a hospital. That is not a government function. You look at what the statute says the hospital board's responsibility is, and there's a whole list of governmental functions. But what they contracted with Great Plains Kiowa County, Inc. to do was to operate the hospital. Great Plains Kiowa County, Inc. operates the Kiowa County Memorial Hospital, and that's the private corporation.
How is operating a hospital not a government function when it's a public hospital?
We have cases cited in our brief that indicate it's not a governmental function.
Just
If you go back, I'm sorry. I didn't
No, you go ahead. I was interrupted.
If you go back to your Knutson Memorial Hospital Association case, it's very clear that it is not a governmental function. It simply is not. And if you
So just conceptually, then would that logic carry across the board? So for example, if a private entity was contracted with by the government to run a prison, let's say, is that private company not engaged in the performance of a, quote, government function?
And that happens a lot. You have a school that contracts the custodial service to a private contractor, and that custodial service does nothing but the maintenance of the
You don't
school.
see a distinction between a custodial service or a concession stand and the actual function of the entity? There's not a distinction there? In other words, when you contract with a service provider that provides a janitorial service, let's say, you don't see a distinction between that and the overall function of the entity of a hospital?
No, because it is the service that is the function. And what the hospital is doing, or what the Great Plains of Kiowa County, Inc. is doing, is operating the hospital. It is a function. And that function that is being performed is not a governmental function. Look at the litany of descriptions in the statute on what the hospital board's responsibility is. And those are truly governmental functions. They took one function that was not governmental and leased and entered a lease with Great Plains. And
I guess how is not running a hospital, as Justice Stegall just said, not performing at least a quasi-government function, but not the government function that was intended by the enactment of the statute that allows the establishment of county hospitals?
Well, the fact is, as the case is outlined and as the Knutson case describes, it's not a governmental function to operate.
Knutson deals with the Open Meetings Act, and Knutson basically stated that because the entity didn't have a government decision-making authority, which is different than the function that's being performed by the hospital. No one's saying that that your client has government decision-making authority, but it does receive government funds to perform its function.
Well, so do the vendors. But the fact is that it's not a governmental function that they're performing. They don't have taxing authority. That's reserved for the hospital board. They don't have, they're not a political body. They're a private, nonprofit corporation. If it's as you suggest, then how do you draw the line between vendors, and how do you draw the line between others, like lawyers that may have official documents?
Perhaps, I'm sorry, I didn't mean, perhaps the difference would be that in a situation like this one, Great Plains has the authority to go to the board and ask them to levy taxes via the county. So would a vendor have that authority?
Well, a vendor can ask for more money for their service or for their product, and if they do, it may put the taxing authority in the position to raise taxes, and that's exactly the same situation here.
But there's no express authority in the situation you just outlined for that to happen. You're saying that is implied. Is that correct?
No, it's clear from the statute that Great Plains, Kiowa County can't raise taxes. All they can do is go to the hospital board and say what it costs. Now, the hospital board can raise taxes as a result of their request, or they cannot. That decision isn't with Great Plains. That decision is with the board.
But is there not expressed authority in this system that grants Great Plains the authority to ask the board to levy taxes through the county, which is different from a lawyer saying, I'm going to provide some services to Great Plains, and therefore there's nothing statutorily providing that authority, is there?
No, all they can do is tell them what their budget is going to be to operate the Memorial Hospital. That's what they report to the hospital board, and the hospital board then enters the business of governmental decision making on whether to increase taxes or not. That's not a decision that my client makes. They just simply tell what it's going to cost to operate the hospital. They are truly in the same line as the vendor we're talking about in terms of their performance of a function. And what the function they're performing, if you look at your cases and the cases we cite in our brief, they are not governmental function to operate a hospital. They don't have any taxing authority.
So your solution for the county to receive the records that they are seeking is what?
If the county wants to receive the records they are seeking, they look to the hospital board, they look to the statute, and if the state of Kansas, if the legislature wanted those records to be vested in the hospital board in its oversight of the lessee, then it should be spelled out what records they should retain.
In the lease.
In
the lease or in statute?
Or in the statute.
Can I move us off of whether they get money and who's taxing
Sure.
whom and et cetera, and just ask you a real simple question? Under 45-217 F1, why is your client not an instrumentality of a taxing subdivision?
Because an instrumentality to me is an instrumentality, an alter ego that performs a delegated governmental function. And we're not performing any governmental function. If you look at the open meetings case,
Let me stop you just a second and ask this. Is the hospital board a public agency under CORA?
Is it a what?
Is the hospital board a public agency under CORA?
Yes.
Okay.
The hospital board is, but not their lessee.
And you just said that an instrumentality is some being that's delegated a job of a public agency. Why hasn't that happened through the lease here?
Well, because it's not a governmental function that's being if the hospital board delegated to some private company the business of raising taxes or the business of supervision, if they took some of their governmental function and used that as an instrumentality with another company, then we'd be here having Cora perhaps apply. But this is a non-governmental function that was delegated to a private nonprofit company.
Counsel, how does your argument not just sort of gut Cora when it comes to the delivery of public services? Because now, I mean, how could we rule in favor of your client without creating a rule that says anytime a government agency delivers public services, they can avoid the application of Cora by just contracting it out with a private party?
If it's a non-governmental function, I would tell you that my solution for that would be to go to the legislature and refine that exclusion. Because that exclusion says you're excluded if you provide a product or a service. And operation of the hospital is a service. And it is not an instrumentality because it is a non-governmental function. And if Cora's language is too broad, it's because of that broad exclusion. So to the question, does it gut it? My answer would be, it's not gutting it, it's there as the exclusion.
How do you understand that the exclusion includes the word solely? Any entity solely by reason of payment from public funds for property, goods, or services of such entity. What does the word solely mean, or in this context?
Solely means that they receive their funds from the governmental entity. And 100% of the dollars given by the board to the Great Plains is spent to operate that hospital. So it is the vendor situation in the sense that the 100% of the money that they give the hospital is used for that function, that service, which is the operation of the hospital.
So essentially, this exemption really does swallow Cora, and any entity that receives public funds is exempt from Cora. Is that right?
No, it doesn't swallow Cora because Cora applies to the hospital board and Cora applies to the governmental agency, but it doesn't apply when that agency contracts for a good or a service.
So can the hospital board hide how public expenditures occur, how taxes are used by delegating its operations to Great Plains or any other entity like this?
If the statute required them to keep certain financials, and it doesn't, but if the statute required them to keep certain financials and they delegated that authority to somebody else to keep those financials, then I would say that's an instrumentality. And we may have that argument at that point. But we're talking about a Great Plains, Kiowa County, that is a private nonprofit company that absolutely performs a service. It delivers hospital care to Kiowa County.
You would agree your lease agreement requires your client to manage the hospital, right?
Yes. And incidentally, the Great Plains furnishes regular financial information to the board. It provides that information. The fact that the hospital board doesn't keep it, I think, is an important consideration here. They didn't keep it, but the Great Plains Kiowa County Inc. supplies regular financial information to the board.
Let me tell you the place where I'm hung up so that you can respond to it, and I think you've been talking around it, the edges of it. But my problem is the statutes give the hospital board two ways to do its job. One is to do it, and the other is to contract for it to be done. Specifically 1946-11 sub D the management, which is what the authority under which you have your agreement. And so it seems, and the case law seems to say that because the board has those two methods, statutory methods for doing its work, that when you have the responsibility to manage the hospital, you've got to be an instrumentality of the public board. I don't see how you're not. So get me off of that if you can.
Well,
And if you're an instrumentality, then you would agree, if you're an instrumentality, you've got to produce these records.
yeah, the hospital board supervises through the lease our client, the Great Plains, Kiowa County. It doesn't delegate the supervision of the hospital to us. It delegates the operation of the hospital and the supervision of the operations.
It's got to be, the only way to read that release agreement, I think, is to say that it's authorizing your client to manage the hospital. And management of the hospital is under the statute, the thing that this board's supposed to do. They can
Well,
either do it themselves or they can enter into a contract.
I would agree with
And so
you.
you have to be an instrumentality of that body if this is what you're doing.
I need to mention that the instrumentality argument was never raised until appeal.
Right now, I don't care about that. I'm just trying to figure out what the law is.
I would agree with everything you just said if the hospital board did not retain the management responsibilities. They didn't delegate those completely to the hospital, to Great Plains, Kiowa County, the lessee of Kiowa County Memorial Hospital.
What specifically in the lease are you pointing to for that statement about the delegation or non-delegation?
It's in the same paragraph that gives assigns the responsibilities on financials and reporting to the, I don't have the lease in front of me, but that specific paragraph where the duties are delegated.
Do we have any more questions? Council, we've taken up a lot of your time with questions. Do you need 30 seconds to wrap up, or do you think you've made your points?
I think I've made my point. I'd just be plowing ground we plowed before.
Very well, thank you.
Thank you.
May it please the court, Assistant Solicitor General Dwight Carswell appearing on behalf of the state. The state agrees that the Court of Appeals should have addressed whether Great Plains is a public agency for purposes of CORA, but we disagree with Great Plains on the answer to that question. The Court of Appeals should have held that Great Plains is a public agency for two reasons. First of all, because Great Plains is supported by public funds, and second, because Great Plains is an instrumentality of the County Hospital Board.
Did you make that argument before?
The instrumentality argument was not raised before the Court of Appeals. However, we maintain that it's the same issue that was raised, whether Great Plains is a public agency. That's how the issue is framed in their petition for review.
And so your position is, as long as you're talking about the same issue, you can make different arguments on review.
That is our position, and in support of that, we cite Supreme Court Rule 6.02A5, which distinguishes between arguments made in support of issues. There can be multiple arguments in support of the same issue. And here, in interpreting a statute, when the issue is whether it's a public agency as defined by statute, you have to look to the entire definition. You can't just pick out words and ignore other words from that statute. So it's appropriate to consider that. On the first point about being supported by public funds, there's no question that Great Plains...
Excuse me, Counsel, this was also disposed of on summary judgment, wasn't it?
It was.
Yeah. So it's pure matter of law for the court.
Exactly. Even assuming it were a new issue, it's a pure matter of law that can be raised for the first time on appeal. It's in the public interest. Obviously, taxpayers provide a substantial amount of funding to Great Plains, so it's an important issue. And also, the district court held that Great Plains is a public agency. This is just another argument in support of the district court's conclusion. On the fact that Great Plains is supported by public funds, obviously it receives a substantial amount of money, but Great Plains claims that it falls within the exception in F2 of KSA 45-217. Great Plains argues that that is an exception for any entity that receives public funds and solely uses those to provide goods or services. If that were true, all kinds of traditional entities would be exempt.
Counsel, can I ask you a statutory question about that
Sure.
provision that you just mentioned, F2, what I'll call the vendor exception?
Okay.
Is the vendor exception and the language in F1 about an instrumentality, are those mutually exclusive, or is it possible to be an instrumentality and then also be exempt under F2?
I think they are mutually exclusive as well as the supported
So
by language.
if an entity, your understanding of the statute is that if an entity is an instrumentality under F1, that it's legally impossible for that entity to claim what I'm calling the vendor exception in F2.
That's our position. We think F2 helped clarify what instrumentality and supported by public funds means. Basically, what the legislature did is they tried to define this term by basically a dichotomy. They defined what it is and what it's not. And by defining what it's not, that helped clarify what the language in F1 is. So under Great Plains' interpretation, if anyone who receives public funds were exempt, that would exempt a whole host of traditional government entities. A police department, for instance, receives public funds to provide police services and would be exempt under their theory. Even the county hospital board, just like the Great Plains, receives public funds, taxpayer funds, to run the hospital. If they hadn't entered into this lease, would they be exempt? Surely not. So the only reasonable way to interpret F2 is saying that receiving public funds to provide goods and services is not sufficient. Something more is required. And what more is required, as I was discussing earlier, is specified in subsection F1, being supported by public funds, or being an instrumentality of the state or political subdivision. In terms of what supported means, we find additional support for the state's argument in a couple of cases from other states. The North Dakota Adams County record case cited in the state's Court of Appeals brief said that support means something more than an exchange of money for identifiable and specific goods and services. Likewise, the Indiana Supreme Court in the Indianapolis Convention and Visitors Association case said support doesn't include a quid pro quo, which it defined as measured goods or services given in exchange for payment based on identifiable quantities or goods and services. So the distinction these cases draw is between, on the one hand, general financial support, in the sense of being propped up or sustained by taxpayer money, and payment for specific, identifiable, measurable goods and services. That's the distinction that makes sense. It's the best way to harmonize subsection F1 and F2.
Are the foreign jurisdictions that you cite from, how do their Open Records Acts compared to CORA?
Sure. Both of those cases were interpreting the word support. So we think they are relevant to the definition of support within the Kansas Open Records Act. I don't believe either had a subsection like F2, which in our view, the legislature was basically writing into statute what those courts did in defining support.
So those states did not have the vendor exception.
They did not have the vendor exception, although the courts there read that vendor exception into the word support. So our view is what the legislature was doing in F2 was basically what those state Supreme Courts were doing, is saying support can't be read that broadly. If it weren't for F2, support could be read to mean any payment of public services, in the sense of someone might talk about supporting the local business by shopping there, just any payment for a commercial transaction. F2 makes clear that support shouldn't be read that broadly. It should be read more limited, like the Indiana and North Dakota Supreme Courts held. Turning to the instrumentality argument, one common definition of instrumentality is a means through which the function of another entity is accomplished. That definition's from Black's Law Dictionary. That's the one we propose here. We think the context of CORA further supports that definition. If you look at instrumentality, CORA does include some traditional government agencies in its definition of public agency, but it also includes the phrase any other entity supported in whole or in part by public funds.
So, Counsel, your view of instrumentality is that it does not require that whatever the instrumentality is doing is a government function.
Yes and no. Yes and no.
Because that was
no.
definitely the gloss your opponent was putting on it.
Yes, I agree. No, in the sense of sometimes courts have tried to draw a distinction between governmental and proprietary functions that governments do. We don't think that's the distinction. What our view is that it's a governmental function in the sense of, is it a function that's assigned to that particular agency by statute?
The taxing.
Yes.
If the government does it, it's a government function.
Precisely.
How is operating a hospital a government function?
Well, KSA 19-4601 says the hospital board is vested with the management and control of the hospital. And then the lease, the KSA 4612, clarifies that the lease here is a contract for management and control. Uses the exact same language, management and control. So the authority that's given to the hospital board is being contracted away to the Great Plains in this case. And therefore, in our view, it is an instrumentality. Additional support
The
is
test being solely that it's in the statute.
from the fact that the statute assigns the function of operating the county hospital to the hospital board. It allows them, of course, to enter into these contracts, but in doing so, the hospital board is transferring that governmental function to Great Plains.
Well, is there a distinction between, the statute allows or tries to ensure that a hospital may be available to the citizens of a particular county or a particular area? That's maybe a government. Is there a distinction between that and the actual operation of the hospital?
The statute, I think no. The statute refers to management and control of the hospital. That's what the board's supposed to do. And that, according to KSA 19-4612, is what these contracts involve. It's a contract, the statute says contracts for management and control. So it's that same authority that's being transferred, that governmental authority. Additional support for our view of instrumentality comes from the fact that KSA 45-216 says KORA should be liberally construed, and it's certainly in the public interest to learn how their taxpayer funds are being spent. So the purpose and policy behind KORA supports reading instrumentality in that way. Also, the relationship between KORA and COMA supports our view. Great Plains claims that COMA, based on the Memorial Hospital case, and KORA should be read in peri materia. But in peri materia doesn't mean you have to interpret them identically. It just means in construing the one, you look to the other. And here that supports our position. COMA came first and uses a phrase to define what entities are subject to it. When the legislature was writing KORA, they could have easily copied that definition. And they did use some of the same language. But they made some changes. They added the word instrumentality. And while COMA uses the word subordinate group, they didn't use that in KORA. They used the much broader term, any other entity, supported in whole or in part by public funds. So you should assume that the legislature, in adopting these changes to that definition, intended the two acts to have a difference. Finally, our interpretation of the word instrumentality addresses the concerns like those addressed in the Letting the Sunshine In law review article about public agencies basically delegating their authority to other entities and therefore avoiding public scrutiny. If it weren't for this lease agreement, the county hospital board would operate the county hospital, and their records related to that operation would be open to the public, except unless closed under specific exemptions, of course. By entering into this agreement and transferring the function for operating the county hospital to Great Plains, it makes sense to say that the records that would have been open remain open. They're still involved the use of taxpayer funds to run this public hospital. So for all these reasons, we think the word instrumentality should be given that definition of a means through which the functions of governmental entity are accomplished.
You refer to this as a public hospital.
Yes.
Is that right? Well,
County hospital.
do the nurses work for the county or do they work for the hospital? Do the patients pay the county for their bill? Insurers reimburse the county for their expenses, or does it go to Great Plains?
I mean, it goes to Great Plains, but what's happened, if there weren't this lease agreement, the county hospital board would be responsible for the management of the hospital. The hospital, real estate and all that is public. It belongs to the public, but to the county specifically. And so by entering into this agreement, even though the employees would work for Great Plains as a nonprofit corporation, not directly for the county, the Great Plains should still be considered a public agency for purposes of KORA. I mean, other
I
contracts would be
understand the
different.
distinction, but it's not exactly a government hospital, is it?
It is. I mean, the statutes refer to it as a county hospital. It's clear that the real estate belongs to the county. It's a lease to run it. It's not transferring this hospital. It's not a private hospital. It's still a county hospital.
With regard to what I hear your argument being is that if the board did it, the record would be open, so when they contracted it out, it still should be open. Doesn't really fit within the express exception for a vendor, because if they did the accounting work themselves, all of that would be open record. But if they contracted with the vendor, you would agree that an accounting firm wouldn't have to open up their records.
for a couple things. I mean, first of all, there's the supported by public funds, then there's the instrumentality argument. In terms of the supported by public funds, the accounting firm presumably would be providing specific and identifiable services, and so it would fall within that exception and not be supported by public funds. With respect to the instrumentality, coming back to Justice Stiegel's question about the relationship between F2 and F1, F2 helps clarify what F1, including the word instrumentality, means. So when you're talking about an entity performing the functions of another governmental entity, you're not talking about just contracting to assist that governmental entity. You're talking about a wholesale or a large-scale transfer of the governmental functions. Like, for instance, in this case, or like a private company running a prison, for instance. Those types of situations where there's the function of the government entity being transferred, not just the governmental entity hiring someone to assist it perform its functions.
I'm not sure with your support function, I'm trying to figure out if you had a large national hospital management company that came in where this hospital was just a very, very tiny asset in their entire structure. How does the support argument fit with that?
I think it would be the same analysis because the statute uses the phrase supported in whole or in part. So you don't look at the amount of support, you look at basically the character of the support. Is it general financial support, like here, where there's money just being provided to sustain the operations? Or is it a contract for specific goods and services? Like the state Supreme Court cases I mentioned, where it's look at the identifiable, measurable, that sort of thing. So if this were the same situation, but Great Plains, rather than being, in this case, it's a subsidiary to another entity, if it were just a part of another entity, it would be the same analysis in our view.
Would you just briefly speak to your cross appeal, the Court of Appeals decision to remand?
You're talking about in terms of whether the phrase instrumentality was raised?
No, well, do you agree with the Court of Appeals that this is subject to a remand
Oh,
to
I see.
determine which records are subject to CORA or not, or is this just is your position just a straight reversal and these records are open?
Our position, we don't agree 100% with the district court's decision, but
No, I'm talking Court of Appeals.
right. But we think the Court of Appeals should have affirmed the district court and held that these records are subject to CORA and affirmed the $500 fine for not providing them.
But-
because at the district court, go ahead.
No, the Court of Appeals said this is subject to a remand for the district court to determine which of the records are actually subject to CORA, which is an open record request.
Sure.
Do you agree with that?
No, we do not. The Court of Appeals opinion, we disagree with its analysis. The Court of Appeals said we don't need to determine whether this is a public agency. The important question in the Court of Appeals' view is whether these records relate to a public function. And we agree with Great Plains that that's not the correct analysis. You need to determine whether Great Plains is a public agency.
Right.
And so the question of whether these records relate to a governmental function, that's...
And once it fits under the government agency, then the records would be then ordered, released, and open.
Precisely, unless there were some exemption. And at the district court, Great Plains didn't argue for any exemption. Their argument was just, we're not a public agency. So the district court's judgment should have been affirmed in our view. Unless there are any further questions?
Any more questions? Do you need any time to wrap up?
The state would just urge you to affirm the judgment of the district court and hold that Great Plains is subject to CORA. Thank you.
Thank you, counsel.
I'd like to respond to a couple of questions and remarks by opposing counsel. I looked back in the exchange on the summary judgment motions, and it is undisputed that 100% of the money that is provided by the hospital board is provided by Great Plains for the provision of services. None of that money, according to the record and the undisputed facts, goes to any management. It all goes to services. And by the way, the entire funding of the Kiowa Memorial Hospital and its operation is a combination of funds from the county, federal funds, and patient pay. But it is undisputed that 100% of the money from Kiowa County is provided for the provision of services. I
Are those
think,
services enumerated, or is it just general services?
what's the services of operating the hospital?
Exactly. So how can you say that they're not services for management?
Well, because
operating
they're
includes
services
management.
that go to patient care. They're services that are involved in operating the hospital. And
This is my question, Mr. Rube. How does operating the hospital not include management of the hospital?
well, it may not, but the key.
No, I'm asking, doesn't it necessarily include it? Maybe I'm not making my question clear.
No, you are.
Okay.
And I'm probably not doing a very good job of responding directly to
Okay.
it. And I would tell you that I would be obfuscating if I stood here and tried to duck that question. It does include some degree of management.
All right, thanks.
But the dispositive word here is services, because services is what is excluded. And I'm going to sound like a strict constructionist for a minute, because I want to go back and read the actual statute on what it says, because we've kind of got a couple of different interpretations going here. F1 says public agency means the state or any political or taxing subdivision of the state or any office, officer, agency, or instrumentality thereof. The instrumentality issue relates to the political or taxing subdivision of the state. It is a governmental function that is being talked about, and if that is what it is, the instrumentality, then I think we are looking at CORA issues. Subsection 2 says, public agency shall not include, and in the insurance coverage, this would be an exclusion, any entity solely by reason of payment from public funds for property, goods, or services of such entity.
Counsel, do you, on that exact point, do you agree with the state's position that those two sections of the statute are mutually exclusive?
No, I think you read them together.
So you think your reading of the statute is that the first question under F1 is maybe we are an instrumentality, but that doesn't preclude Great Plains from then claiming the F2 exclusion.
I would respond to it this way. I would say under number 1, we are not an instrumentality.
I understand that's your position, but assume that we disagree with you and find that you are an instrumentality. Do you think that that ends the inquiry, or do you think we still have to ask the F2 question?
You asked the F2 question, and then we're excluded.
And what's the basis for that?
The plain language of the statute.
Okay.
And your argument is that you're not an instrumentality because the taxing authority of the board was not delegated?
Correct. And nor any of the political function of the board was delegated. The governmental function is retained with the board. And if the board, and if the county attorney or anyone wants to inspect the records of the board, they can ask the board for that. If the board doesn't have them, because the statute doesn't require them, then the fix is not to shift the Kansas Open Records Act to some entity that is a private nonprofit corporation. The fix is to go back to the legislature and get delineated what the hospital board, as a matter of their existence.
Or require the boards, if they're going to delegate, to maintain the records.
Exactly. And the lease agreement that we have calls for regular financials according to standard accounting practices, and that's what Great Plains of Kiowa County, Inc. does. Thank you.
Any more questions? Thank you, counsel. Thank you both for your arguments this morning. Clerk will take this matter under advisement. Call the second case on this morning's docket, case number 116146, State of Kansas v. Daron King.
If it pleases the court, Michael Highland appearing for the appellant Daron King. I will be requesting 3 minutes, if that's all right, at the end for rebuttal.
3 minutes is granted.
Thank you, Your Honor. This case involves it is a criminal case. It involves one of 3 individuals who were charged and convicted of 1 count of attempted capital murder, 3 counts of aggravated robbery, 2 counts of aggravated battery, 1 count of conspiracy to commit aggravated robbery, and 2 counts of criminal possession of a firearm. My client, Mr. King, was sentenced to a life sentence with a mandatory 25-year sentence and a consecutive 49 months to follow. There are a couple of main issues. I did put the issues that I saw in this case into the brief. I did not try this case. I was only appointed on the brief, and I will not reiterate what was in the brief. I know you've all read that, but the biggest issue, I think, was the prosecutorial error that came about when the prosecutor used words like, "we know," "I submit," "I don't think," "I believe," when she was talking about the evidence in the case. In this particular case, Your Honors, there was a large amount of KSA 6455 evidence admitted by Judge Burdett. This wasn't the only robbery that happened, the one that was detailed here, and the only shooting. There were at least 1 other case in Kansas City, Kansas, and at least 3 cases in Kansas City, Missouri that were given to the jury. They saw witnesses, they saw all kinds of evidence, they saw 3 guns that weren't involved in this case, a lot of clothing and photographs and movies from these different robberies. All of that went to the jury, so they had more than just the information in this case on which to try this defendant. Along with the 455 evidence, you had the circumstantial evidence, which is what this case was all about. There was no physical witness identification, no facial features, anything like that. It was all circumstantial based on clothing, tennis shoes, the things that they observed in the movies at these different robberies. What I would submit to you, judges, is that because of the 6455 evidence, which was substantial, and because of the circumstantial evidence, which also there was quite a bit of it, it wasn't just 1 or 2 things, that would have been maybe enough for the prosecutor to leave it alone. I'm not saying that would have been enough for a conviction, but she should have stopped there. Even if she had gone to the jury and maybe once or twice said, "I don't think this," or "I believe this," maybe once or twice wouldn't have been so bad, but I quoted 14 times in my brief in the statements, but actually she did it more than 45 times. What she was commenting on was not all uncontroverted, or controverted, excuse me. She was commenting on controverted evidence, unsubstantiated evidence, as if it were factual, and it caused the jury to believe that it was factual, is my assertion to you. There was so much of it that the jury just thought, boy, they've got this guy hands down.
Mr. Highland?
Yes,
Can
ma'am.
we tease that apart a little bit, the numbers of remarks and exactly what their content was? I'm sorry, could you not hear me? Let me speak it up again. I'd like to tease apart a little bit the number of times these things were said and what exactly was said, because I don't think they're equivalent to one another.
You mean the 14 times that I put in here?
I think we've counted up 22 I submits, 36 we knows, 2 I believes, 2 I thinks, 1 I don't think.
Okay, well, I'm sure you're accurate on your count. I didn't actually count it.
Let's just assume that's a working number, okay, for purposes of this discussion. How is I submit error? Why isn't it equivalent to the evidence demonstrates?
Okay, I know that I submit is one that prosecutors use, and it's what the Supreme
And
Court
defense
has-
lawyers
they should
too.
use.
Yeah, and in fact, I think the defense lawyer did use it in this case.
Yes, and so, and I'm not saying that was in itself what caused it. It's just it was one of many. That was one of many of the different phrases that she used.
I understand it's one of many phrases, but we're trying to decide what's error here.
I
And I'm
understand.
asking you to talk specifically about I submit. I just don't see what's wrong with that.
Okay,
Is it just the worst use of the word I in front of it? Is any phrase that includes the word I potentially error? Is that your position?
There was one for sure, if I can see it here. At the top of page 10 of my brief, I wrote, I submit to you that the evidence presented to you is sufficient to prove that these two defendants, Dyron King and Cecil Matterson, are guilty beyond a reasonable doubt of the crimes charged. Because of the evidence, she's saying, I submit the evidence to you that causes them to be guilty. It may or may not, it's just evidence, and they're the ones that determine guilt.
Isn't that the whole point of the state's prosecution, to submit the evidence to the jury? Again, I guess I'm just,
Okay,
how
let me
is
go-
that improper?
I understand your question. Let me go one more. On down the page it said, and now this one I think was a leap. And I submit to you that those are the same shoes that have Brendan Foxworthy's blood and the same shoes that have Dyron King's wearer DNA that recovered in his bedroom. So it automatically tells the juror, well, if the police officer's blood is on those shoes and they were found in my client's bedroom with his DNA on it, he obviously is the one who shot the officer. And that
But
may or
isn't
may not
that
be true.
what
In fact,
prosecutors do? They
Excuse me?
isn't that what prosecutors do? They admit evidence
they do.
under the supervision of the court,
Okay, well.
and then they argue at the end, now you've seen all this evidence, here are the different pieces. That adds up to guilt.
I understand.
I just think I submit is different from some of these others.
It is, and
that
I
you complain
agree with
about.
that. I know that's the one the Supreme Court actually tells prosecutors to use most of the time, and I understand that.
Okay, thank
So
you.
if you like, I'll go along with the I don't, the I don't think, or the I believe, or the we know. So those I think were ample in themselves.
There were a lot of we knows.
There were. And again, if she had only done it once or twice, it wouldn't have maybe been such a major thing, but it was done so many times that the jury heard it over
And
and over.
just so I understand your position on the we knows, you're not really complaining if they are in fact introducing a reference to evidence that is undisputed.
Well,
Would you
okay.
make that distinction?
Well, it could be, but the very next one after that is, I submit, this is where they were leaping again. We know that Dyron King's DNA is on one of the Easton batting gloves that was recovered in Charles Browser's Lincoln in the driveway of Dyron King's house. So we know that was recovered. And we know, based on what you can see in all the videos and the still photos that have been taken, that those Easton batting gloves are used in every robbery from Don's Liquor all the way to 7-Eleven. We don't know that. Similar gloves or some that look like that, but we don't know if those are the gloves. And
That particular pair is what you're saying.
Okay, yes, and she could have at least said, we know that looks just like the pair, but she said those are the gloves that were used in those robberies. We don't know that, and the jury was told that those were the gloves. So those are the problems we have with that, Your Honors. And the
So
only other
just
thing
to-
I have.
Counsel, I'm sorry, I just wanted to clarify.
Surely.
It sounded like you, in your answer to my colleague, you agreed that if the evidence was uncontroverted, the statement we know could be proper. But in any instance in which there was a possibility of a different interpretation of the evidence, saying we know is improper. Have I correctly paraphrased your argument?
Probably. I probably wouldn't say set in stone that's correct, but, and I know that some of these, there were some uncontroverted evidence and some was controverted that she was talking about. So give a few, take a few. There were just several that she shouldn't have done it on, is my argument. The other big issue that I have, Your Honors, is, I'll be brief here, the antagonistic defense that was put forth by the co-defendant. There originally were 3 defendants. One of them asked to have his attorney withdrawn, and he was appointed new attorney, so his case was severed. And these 2 defendants, their attorneys had agreed that we're just going to go and have the prosecutors put on the evidence and prove that our clients are guilty. And that was pretty much how the trial went. It was a 10-day trial, a lot of transcripts, but it was at the closing that the other defendant and his attorney completely deviated and started saying the things that I listed in my brief about how all the evidence points to Mr. King. It's not my client. We know Mr. King did Mr. King did this, there's no evidence against my client. And at that point, my client was no longer only fighting the prosecution, it was fighting the defense, and it should have had a severed trial. I
Mr.
understand.
Hyland, yeah, I was just gonna say, why wasn't it incumbent upon defense counsel at that moment to leap from his circle chair and say,
It was. And
Your
the
Honor,
only,
I need a severance now?
Your Honor, I believe it was error on the part of the defense attorney to not do that.
And a waiver, right, by your
She's-
client? A waiver of his right to
I know
sever?
that if you don't bring it up right then, that you lose that argument for appeal. But in this particular instance, I know there are some exceptions. I don't know if this falls within them, but I can tell you that ineffective assistance of counsel is one that this client will raise on a 1507 for sure, because she did not bring up
Are
that
you
issue.
seeking a Van Cleve remand today?
I'm sorry,
Are you seeking a Van Cleve remand today?
if that means you'll allow this to be decided on its merits rather than just dismiss it forthwith, yes. And that's all I have, unless you have any more questions.
Any more questions?
Thank
Thank
you
you,
very much,
Counsel.
Your Honors.
May it please the court, Ethan Ziv-Sigler from the Wyandotte County District Attorney's Office. I think I'll start with the prosecutorial error analysis. There is, I think the most, probably the one that comes closest to the edge of being prosecutorial error is the comment that, and we know the gloves were used in the robberies. The state would submit that is a very poor way to word that. The prosecutor probably should have prefaced that by saying we know that consistent gloves were used in each of those.
Yeah, it's not just poor, it's wrong. Right?
I believe, yes. I believe that based on what the court has held, yes, that saying we know they were the same gloves would be error.
So how is it? Just move over and talk about reversibility.
I do not believe this comes close to a reversible issue. It is a very minor piece of evidence that in a mountain of evidence against this defendant, including the Deputy Scott Wood's DNA was found inside the chamber of the revolver that was in Deron King's room. The consistency of the pattern of robberies between the 5 robberies,
Was that the only article of clothing that was consistent across the entire group? I think it may have been.
It may have been the only one that was consistent across all 5 robberies, but it wasn't the only one that was consistent across multiple robberies, including the robbery of the 7-Eleven.
Right. There
So
were several different items of clothing and lots of other things that were consistent from one to the other among them. That's the one that sticks out in my mind as showed up in every video.
I believe, I actually don't know if it was in every video. I don't know
Okay.
if it was in the Family Dollar video.
May have just been testified to. Okay.
And I don't, that's the only one that I don't know about the Family Dollar. I do know it was consistent in the other 4. There were other pieces of clothing, though, that were consistent in 1 or 2 of the robberies, and then other pieces of clothing that were then consistent in separate robberies. And when you put them all together, you connect all 5.
Yeah.
You also have the blood of one of the victims from Missouri on the shoes that are recovered, and then the wearer DNA also being of Deron King inside his house. You also have, and this is extremely important, you have the products, the ill-gotten gains of the robberies, the liquor bottles, you have the coin wrappers, you have gray plastic bags that are consistent with the gray plastic bags that they were emptying the cash into are recovered at the house, and so is just a pile of discorded currency. So yes, while the statement is an error, it would have virtually no impact on the jury, particularly when you take into account this was a 10-day trial. There are over 1,800 pages of records. A single statement made by the prosecutor would not stand out to the jury compared to the other evidence that was presented. So I think it is, I am absolutely safe in saying that there is no reason to believe that it had any impact on the jury's verdict in this case.
Would you make the distinction that we discussed with your opposing counsel that we know might be okay if the evidence is undisputed, but it's problematic whenever you have a situation where the evidence is still ambiguous or subject to competing interpretation.
And that is the case law. So if it is something that's uncontroverted, you can say we know. For instance, I mean, the classic example, I guess, would be if both parties say that they were there, if a defendant were to say that they were there and we say we know the defendant was there, it's uncontroverted, so it's not an error. And I agree in this statement, the one that is most controversial is that we know the gloves were there. I think it is very easy to believe for a jury to have read in the correct reading, which is that it's consistent, and make the decision for themselves. I also think that when combined with all of the other evidence, that it's not that the gloves are consistent or that the gloves are a major factor. It's that this one statement about the gloves would not have stood out to the jury in any significant way, considering the length of the trial and the amount of evidence that they had seen. So I'm very comfortable saying that this should not be reversible error. I am comfortable that it was error, though, in that one instance. I do not believe any of the I submit or we submits are problematic. I believe a lot of the other I thinks are not. If you look at the context, it is saying, like, looking at the evidence as a whole, I think you will find that rather than...
Sometimes people say, I think, to soften a statement, too. And sometimes they go, I think, don't they? So we don't know that.
Right.
Here. I mean, in a 10-day trial, it's possible that a human prosecutor might not remember every single thing that happened exactly as it happened and might soften a statement with, I think, in that tone, isn't it?
I mean, it would be possible. I don't know if that's what happened here.
Okay, we can't know. That's my point.
Correct. I think you can look at the context, though, to see what it was being used as. If it's being used simply as a soft, I don't know what the evidence shows, or more of a, similar to saying I submit to you.
Assertion of opinion. That's what you're trying to avoid, right?
Correct.
Okay.
And what about the 2 times that the prosecutor said, I believe?
And I think I cover these. I think it's clear from the context of the entire statement, what the prosecutor was saying was that look back at the evidence and look at what we've submitted to you, and I believe it's a case that you can sustain a verdict on, which I think is an appropriate way for her to phrase that. I believe it's kind of the natural way we would talk about the evidence, and I don't think in this case, from the context, it's similar to the cases that the defense cites. Typically when I believe gets in trouble is when the prosecutor is making a definitive statement about credibility.
Yeah, there's a big difference between saying, I believe the defendant's guilty, and saying, I believe that when you look at the evidence, you will conclude.
Correct. Or saying, I believe this witness's story, which is also error, to vouch for the credibility. I don't think in this case any of the I believes are ever in reference to vouching for a defendant's or for a witness's credibility, or to vouching for the final determination of guilt or innocence, which are the 2 contexts in which this court and pretty much every court finds that it is error to say, I believe. Final determinations of evidence, weight and credibility to be given to particular pieces of evidence, or weight and credibility of witnesses' statements. If there are no other questions about the prosecutorial error, I'd like to address the antagonistic defenses issue that was claimed. Obviously, the state's first position is that, I'm sorry. Obviously, the state's first position would be that this is in no way preserved for appeal. I particularly find problematic that the defense waited until the verdict had been returned to raise a question. I know this court has addressed before whether a defense attorney is required to object during closing arguments, specifically because the logic has been that objecting during closing argument may draw more attention to a problematic statement. That's in the context of prosecutorial statements. I think in this case, though, you still have a problem that at the end of the closing argument, when the jury is excused, the defense neither defendant jumps up and says, that statement was an error, these should have been severed, we demand severance now, we demand a mistrial now. There was a strategic decision on the part of the defendant to ride out the evidence that had been presented as it was and wait for a jury verdict. And at the point where you are waiting for a jury verdict, when you have had ample time to ask for a mistrial based on those statements before the verdict, you are trying to get 2 bites at the apple. You are trying to say, we're going to wait and see if we might get an acquittal, and then we're going to bring it back up on appeal and see if we can get a reversal based on that. And that is absolutely inequitable. It should not be allowed. Even if you give the defendant the benefit of the doubt that they did not want to raise attention to in front of the jury, there was ample opportunity once the jury was excused to raise this objection, and it never was.
And if they had raised it before, would you be arguing, well, they haven't shown that it was prejudicial?
Yes, and
That the verdict would have been the same.
Right.
And so the defense, has to be in a position that it was prejudicial because I was convicted,
correct.
you know?
Well, I mean, if they had raised it before, if they had raised the issue for a mistrial, I think what you would get down to is a weight of how much you would get to the argument. The judge would have to make a determination. Was the damage done at trial in the closing argument sufficient to warrant a mistrial? Can it be mitigated by instruction? And we don't even get there. The district court is never even given an opportunity to give any sort of mitigating or limiting instruction to the jury based on the statements. There's no way to mitigate the damage without an objection, which is one of the reasons in equity parties are required to make objections. It's because there is some trial error that can be mitigated with instruction, but here there was no request for a limiting instruction, for a mistrial, for anything. The first time there was an objection raised was after the verdict at the motion for new trial.
And remind me, did both defendants get convicted of exactly the same crimes?
I believe so.
So it didn't work either. The betrayal didn't work.
No, it did not. It did not, at least to the attempted capital murder. Because I wasn't prepping Cecil Megerson's, I didn't look at his journal entry. I know the only count that Duran King was acquitted of was the robbery of one of the victims, and it had more to do with the fact the victim said he wasn't sure if they even took the object that he had thrown from him.
Cell phone from Jones in the one store.
I believe
I
so.
think that was the one he got acquitted on.
And I think that had more to do with not even knowing if the object was taken. I don't know if Cecil Megerson was convicted of all counts. I know he was convicted of the attempted capital murder. I do think in this case, even if the court were to look at the antagonistic defense and the prejudice to the defendant, it's important to note that I believe defense counsel has mischaracterized some of the statements that the trial counsel, James Spees, made at the time. He did not ever instruct the jury to find Duran King guilty. What he said is that both the jury can weigh the evidence independently for both defendants, which is a correct statement of the law. It's in fact what the jury was instructed on, and that they can make a determination independently on both defendants. I will concede that it was quite a strong statement, but it never went as far as saying, find Duran King guilty. There was no point at which he was ever saying, you should find Duran King guilty and my client not guilty. It was more, you can find him guilty and still find my client not guilty, which is a correct interpretation of the law. It's a correct recitation of what the jury was instructed. Furthermore, I think you still get down to the argument, even if there's some prejudice, the evidence against Duran King was overwhelming in this case. And what I'd forgotten to mention earlier is twice in the jail, he told deputies, I shot your friend. And the jury heard this. And that is incredibly strong evidence. He was bragging about this. He seemed to be quite proud of the fact that he had shot a law enforcement officer. So the jury had a mountain of evidence to use to convict Duran King. And neither of these potential errors, either the one prosecutorial statement nor the possibility that an antagonistic defense was presented, denied him the right to a fair trial or in any way would have impacted the jury finding him guilty. And the state believes that argument carries over both to the sufficiency of the evidence argument and to the cumulative error argument. I would ask that you affirm the convictions and deny the appeal.
Before you sit down, do you want to address your opponent's late blooming request for a Van Cleve remand?
I don't think it's appropriate in this case. If the defendant would like a collateral appeal, it can be brought as a collateral 1507. And
it's not appropriate in this case because it wasn't asked for before now or for some other reason?
Correct. It's never been asked for. It's never been before the district court, so it would be a completely original claim while
Well,
it is.
that's the point of a Van Cleve remand, is it's not been before the district court, so we give the district court a crack at it without the extra proceeding of a 1507. Do you have any substantive arguments other than the procedural, gosh, it's late blooming?
Not really,
Earlier
I
you
don't
mentioned you
know-
thought
I
it
don't
looked
know.
strategic.
correct.
Earlier you mentioned you thought it looked strategic.
I do think it was strategic, the decision not to ask for a mistrial or.
But that's something that would be addressed by such a remand, right?
Correct.
Okay, thanks.
Any more questions? Thank you, counsel.
One moment, Your Honor.
Certainly.
The one thing I would say is that counsel just mentioned that my client had made some statements in the jail about shooting the officer or whatever. My client was actually charged with criminal threat, and that's one of the counts that went to the jury, and the jury found him not guilty of that count. Whether the alleged inculpatory evidence is something the jury didn't believe or what, we don't know, but we know that he was not convicted of that count. They were both, it was two officers, two deputies who made those statements, and they were two different statements. They weren't together. They didn't see him. They heard him say them over, I don't know if it was over the microphone or whatever, or at least that's what they said, and no one else substantiated it, and the jury didn't believe it. Other than that, unless you have any questions, I would just stand on my brief.
I have one quick question on the Van Cleve issue. Counsel, have you done any independent investigation of this case outside just looking at the record?
I looked and I didn't find anything on it, Your Honors. I would just admit that if you don't take care of it here, it's going to come up again. That's not a threat or anything. I just know that Mr. King's going to raise the issue on 1507.
All right, any more questions? Thank you, counsel.
Thank you all.
We thank you both for your arguments this morning. Court will take this matter under advisement. This time the court is in recess for 15 minutes.
All right.